Operations Excellence webinar series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective U.S.-based IP docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman, Lundberg, and Wissner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pulled together patent operations experts and managers from the Schwegman firm, Black Hills IP, and their respective clients and customers to help educate on best practices for processing and managing the foreign filing process. The Operations Excellence webinar series is free. This is one of several webinars that we've already presented on various operations aspects of the U.S. patenting process. The webinars are available online. You can go to the Black Hills IP website, which is www.blackhillsip.com, and under the Our Educational Resources tab, find those webinars as well as webinars on a number of other subject matter areas that we have done over the years. For this particular program, we're focusing on managing the foreign filing process for filing U.S. applications overseas. We will allow questions, but those questions will be addressed at the end of the program. The questions can be submitted during the program, though, by entering them in the question box on the control panel on the right-hand side of your screen. And they'll just be held in a queue until we get to the end of the presentation. All right. Okay, there we go. Oops, I have the wrong title. Oh well. The presenters for today's program are myself, Aletha Dobbins, and Chris Rudebush. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 21 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I was a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center in Concord, New Hampshire for 5 years. Aletha, can you tell the audience a little bit about yourself?
Yeah, I'm Aletha Dobbins. I am the intellectual properties paralegal at Zimmer Biomet. We're an orthopedic company in Warsaw, Indiana, and I've been their intellectual property paralegal for the past 8 years.
Well, thank you very much, Aletha. And Chris, can you give an introduction for yourself?
Yeah, I'm Chris Rudebush. I work with Schwegman. I have been with them for 10 years. Started on the docketing side, did a little U.S. paralegal, and now I'm on the international side, which I really enjoy.
Well, thank you very much. And today we have the unique combination here because Aletha and Chris work together on the foreign filing process. Aletha obviously is in-house at Zimmer, and then Chris is seeing the other side, the actual law firm piece of it, when there is a foreign filing to be done. So I think it's kind of cool that we get both perspectives from the same process with both Chris and Aletha. So thank you very much for joining us today and taking time to be part of our program.
Absolutely.
The topics we will be covering today will be, first, a real quick overview of the different options for foreign filing, then the typical foreign filing process from the corporate side and also from the law firm side. Then we'll talk about an example of how the foreign filing decisions are made in a corporate environment, as well as an example of how the law firm environment approaches the foreign filing of the applications themselves. Before we go too far, though, I'd like to find out, well, first let me go through this slide and then we'll do a poll. I know our audience has different levels of experience, and this is probably a review for many people, but I just want to set the stage with the different approaches for foreign filing. There's 3 different mechanisms that you can use to file a U.S. application outside of the United States. Those would be either a direct national application, where you're first filing the application, not first filing, but you're filing the application directly with an individual country's patent office, relying on your Paris Convention for the 12-month timeline to file overseas. And that's typically used if a company is going to file in just a small number of countries. You may just go direct into the National Patent Office. Another option that's similar and is also based on the 12-month Paris Convention timeline would be to file a regional application. So the most common regional patent office that most of us would think of would be the EPO, but there are several different regional patent offices for different parts of the country. So again, if you know you're only going to file in Europe, but you're going to file in several European countries, you may just start off by filing a regional application in the EPO. And then after you get through the examination process at the EPO, then you validate in the individual countries that you want protection in within the EPO. And then finally, the probably most common route is to file a PCT application. That is a way to file a single application that claims priority to typically your U.S. application, and in our context, it would be your U.S. application. And that PCT application then basically is a placeholder and extends the time for the decision to file in various countries around the world. The PCT application now, I think, gives you over 160 some odd different countries that you can file in. I think there's over 160 countries that are members of the Patent Cooperation Treaty now. And that is by far the most common, I think, way that people approach foreign filing. But I'm curious, I would like to see, what is the way our audience members do most of their foreign filings? How do you approach that? So let's take a minute. I'm going to put a poll up with that question. What do you use for the majority of your foreign filings? And I know many people may have multiple mechanisms they use, but which do you use the most? PCTs, regional filings, or direct national filings? And we'll take just a little bit here to let everybody vote. So you should have a window on your screen. Take a minute to select the one that is the most common mechanism that you use in your organization. Okay, as I thought, let's see. So let's see if I can just. As I thought, the PCT application would be the most common process. That PCT application approach was what 76% of our listeners use as for the majority of their filings. 18% just go direct, and then a very small 7% are starting off in regional patent offices. So no surprises there, but I think it's always interesting to see those numbers. Okay. Jumping back to the program, let's walk through a typical foreign filing process from the point of view of a company, and then we'll look at a typical process from the point of view of a law firm. So from the point of view of a company, obviously the companies are tracking their foreign filing deadlines. And the big step in the process is to determine whether or not to file the application foreign. After that determination is made, typically they'll be updating that information in their docketing system or some other tracking system that they use. If the particular record was, or particular matter was selected for foreign filing, then they're probably creating a record in their system to track that new matter. There has to be a way to communicate those decisions to the party responsible for filing. And I say party responsible because it could be that the company is handling the filings themselves and they're doing them internally, or it could be that it's their outside law firm that's doing it. And then if the company is doing the filing themselves, obviously they're going to file the application, and then there's probably some tracking and allocating of costs. So looking at the other side of the process, the typical steps from a law firm's point of view would be, again, tracking the foreign filing deadlines, getting the instructions from the client with respect to foreign filing, then coordinating the actual filing of the application. If it's a PCT application, the actual filing is done by the law firm, as opposed to if it's a direct national or regional application, the responsible party would be the foreign agent here. Well, the law firm would be the responsible party, but it's the foreign agent who's actually coordinating the filing and doing the submission to the particular patent office. And then reporting that the application has been filed to the client and billing the client. So those are your high-level process steps. Now let's talk about some specific examples. Aletha is going to talk about the process at Zimmer Biomet. And one thing that I've been very impressed with as I've worked with Aletha is how organized the process is that they have. And that's why I wanted her to talk about how foreign filing decisions are made at her company, who makes those decisions, how those instructions are communicated to outside counsel. All of those are very interesting things. So, Aletha, I'm going to turn it over to you to give an overview of Zimmer Biomet's process.
Yes, we've had to create this model due to the fact that we have a limited number of personnel that assist in this process. So currently, we have our engineers submit invention disclosures electronically through our docketing management system. And due to the fact that we are FDA regulated, there is a very long process prior to the invention disclosure finally hitting our system. At that time then, and it can be anywhere from 1 to 6 years. So there's lots of research that's done regarding the invention. Once it's submitted, it gets managed through myself and also the divisional responsible attorney. We have 5 attorneys that manage our patent portfolio, and we have 15 divisions that are divided up amongst those 5. So when it is electronically submitted, the responsible attorney reviews the invention disclosure, and then once a month they meet with that division and discuss what the invention entails, the background, and in that meeting they try to assess several factors. It could be a new product, it could be a revision of a current product that we already have, but we try to place a value on that product. And at that time when that value is assessed, several factors play into that, and that results in how we then proceed with the filing of patent applications for that invention disclosure. So when they come back and decide that they are going to file on that invention disclosure, of course the appropriate searches are performed by our outside counsel to even give us the green light. And then once that happens, they decide a tier level for that patent or that invention. And when that tier level is decided, we're kind of working ahead of the process, and that will also then decide on which countries we will nationalize in and how those filings will shake out throughout the process. So once that happens, a form letter is completed by the admin, and it gives several different data points that I would say are very important to the process. So we're given a title of the patent application at that time, or one that we feel that would best suit the invention. We, of course, assign a file number to it, the division that's going to be responsible, because then with our outside counsel, they then work with different divisions, of course. And then also the tier level then is designated, an inventor, that if there's any questions regarding the actual application when they're filing the figures and stuff like that, the engineer can be contacted. So we provide that information at that time. And then also, due to, I'm sure everybody else has this problem also, budget constraints, we're also starting to implement putting a budget onto that initial filing. so that we kind of can say, this is how much we want to spend going forward. And then also allows a ability to work with the two attorneys to, if we're going to expand on that or something like that, they can alert them that, hey, if you file this many claims, it's going to go over your budget amount. And so then they can decide how they're going to go further from there. After that, the attorneys work very closely with the outside counsel, and the tier levels then, when the certain deadlines hit, allow our outside counsel to make decisions without further communications, or just to confirm if this is what they still think that they want to file in or go any further with. And, things can always happen and change on the spur of the moment, but it gives a good groundwork for how we want to proceed.
So, Aletha, just to make sure everybody understood that, you're making the decision of the tier prior to the U.S. application being filed, right? You're making that determination at the point when you're reviewing an initial invention disclosure and deciding, do we file on this at all? And at that same time, you're assigning a tier, which will later will include the list of countries that are later used if there is any foreign filing, correct?
Right, that's correct. In our industry, we have certain countries that we know we need more coverage in. I'm sure with any other type of business than normal, and so we can tell by the type of invention on if that product, for instance, we have numerous patents that don't even have a product that we sell, but it's more for infringement purposes type thing. So with that aspect, you have to place a value on if that is actually going to become a product or not. If it is, then of course it needs more coverage. If it's not, then we can be a little bit more selective.
Okay. So from a process standpoint or an operations standpoint, some of the things that I think are probably factors to the process you have being so efficient are you have regular schedule. You have a regular schedule that you do this on, right? You said monthly meetings.
Yes.
So there's a regular schedule. There's some criteria that's applied when you have these meetings to review the disclosures to assess the value. And then you have the predefined tiers that call out what countries will ultimately be where these applications are filed in. And again, those are based on certain criterias and product lines and things like that. And
Correct.
Then also you've got budget guidance, right?
Yes, unfortunately, that's lately has been another cost factor that we felt best would allow us to. When you work in such a large scenario, there's always somebody questioning somebody's decision. And so with this process, it allows the attorneys to give a little bit more, what you might say, backbone to their decision, in the aspect of somebody who's not familiar with how the patent application process works would have no clue as to how expensive it can be to file an application and take it all the way through the 20-year term. And so to be able to say, we presented this patent application with a 2-level tier, and this is our reasoning why, it tends to give somebody a little bit more information and basis for the decision result. So that way, a VP from a division who might be upset that some of his his invention disclosures of his team didn't make the cut, when you present to them the cost in that sort of aspect, in rationalization, it tends to give them more information and then also aids their team in inventing new products.
Well, I think you have your your company has a very organized process, and just in listening to you talk, I'm sure there's more things that are key to success in your program, but I think the regular schedule, the criteria, the predefined tiers with the countries and the filing strategy as part of that, and then your budget guidance are key operations aspects to why you are able to do so much with such a small team. So that's a great summary. I'm going to jump over now to the law firm side of the process and talk about some different aspects of what happens on the law firm side when you're doing the foreign filings. One of the things that I can't emphasize enough is that planning ahead is essential when you're looking at your foreign filing processes. You can't get down to the last minute and realize that you needed to have an assignment that you don't, or you needed to have a certified copy of a priority document that you don't have, because those things all take time. So some of the big things that should be planned for in your process, if you are the ones that are actually handling the filings, would be having a check early on in the process for formal drawings. If the original application was filed with informals, and you need to get the drawings formalized, particularly if you have an application with a very large number of drawings. You don't see a lot of them, but I have seen ones with 100 drawings that were all screenshots, and it takes a long time to get those formalized. Requesting certified copies of priority documents, chasing people down to get signatures on assignments if your original application, say it was a provisional, may have been filed without an assignment. Any other particular formalities that might be unique to an individual country that you would be required to have signed or prepared, or sometimes you have to go through legalization processes, which take a little bit longer.
Even translations.
Translations. I should have had translations on this list.
Yeah.
That's a great comment, Chris. And then foreign filing licenses, or in some instances, countries where you have to file in that particular country first. So from a process standpoint, planning ahead for things like this, building that into your process is very important. One of the things that I've learned from Chris that they do at the Schwegman firm that I think is a really good process approach is they docket a 27-month review in PCT applications. They have a checklist for this process. There's a number of things that are on this checklist. I've pulled out a few of them as examples. The idea behind this review is that the paralegal at Schwegman is going to take a look at the application, see if there's anything that needs to be addressed before they get to the national stage filings. And they're going to do that with enough time that they can still take care of things to get it in order so that the national stage filing process goes much smoother. Some of those things are making sure you have the correct applicant name and address, making sure, as I said on my earlier slide, you have an assignment from each inventor. If there was anything changed on a Rule 92 bis during the PCT process, confirming that that change was properly made. Making sure you have the international search report, which you don't always have at that stage, and written opinion. If you don't have them, following up to see if you can get them prior to your national stage deadline. If you had requested corrections to the published application, making sure that those corrections were made, verifying that the items were republished correctly if you had anything republished, and making sure that the priority documents have been received by the IB and that the PCT application has the correct priority claim. It's easier to correct it at that stage of the process than in your national stage applications. And then finally, checking at that point to see if you have instructions from your client. And if not, sending out reminder letters, which in fact at the Schwegman firm start even before the 20-month date, or the 27-month date, but making sure you have the instructions and kicking off the reminder process to get instructions. So Chris, I think there's a lot of value in a process like this. Do you have any additional comments on what it does for you when you get to the point of filing the application?
Well, I think I kind of look at my role as I need to like watch out for the client. And so my biggest thing is if all of these items are in order when I start to enter these national stage applications, and like Aletha mentioned, there's many companies that watch their budget. Well, if you don't have all of these aligned and you go into national stage countries, you're going to pay a lot more to have them changed in each country than if you just fix it all in the PCT application. So I think that's the biggest thing, that, it's just a lot smoother. It's easier for all jurisdictions to file and proceed without needing extra documents.
Yeah, so it's a great practice, and it's an easy thing to implement from an implementation standpoint. I believe there's a docket entry for this, right? So it's actually docketed, the 27-month review.
Yeah.
So somebody internally within the law firm has this on their docket. It's assigned to them, and so it's tracked through the docket system. And the entry, I think the entry name is just PCT 27-month review or something quite simple like that.
Yep.
And then there's a checklist that goes along with that 27-month review. And like I said, the items that I have on this screen are taken from that checklist. There's some additional things that are more Schwegman specific and that aren't included here, but these are the ones that I'd say are the key things that you'd want to have on your checklist, and anything else that you'd want at that point. So docket it and create a checklist for it, so you know that everything that needs to be checked at that point in time is checked. That will save money down the road and save time and make the national stage filing process much smoother. Just a comment that I want to add on priority documents. I don't know if everybody's aware of this, but there is an electronic priority document exchange program that a number of the larger patent offices participate in. In this case, the USPTO would transmit certain priority applications to foreign patent offices that participate in this PDX program. There's quite a number of countries that are participating in this, and by doing this, it both saves time and money. It used to be that there was a PTO form, SB 39, that you use to authorize the patent office to transmit the priority document, but now I understand that's actually part of the ADS, and there's a checkbox on the ADS that will allow you to authorize the patent office to transmit documents this way. So if that's not part of your process, that's a good thing to look into. There's more information on the PDX program on the USPTO's website, including the current list of countries that are participating. So just a couple more general application filing tips before we get into the specific process that Chris is going to talk about. Some of these I may have already mentioned, but they're important and I think they're worth mentioning multiple times. Again, make sure you're looking ahead and you're checking to see if any of the inventors on your applications are non-U.S. citizens and resident or non-U.S. residents. And then confirm whether you need a foreign filing license or if foreign filing in another country is required first, according to the laws of the country of that non-U.S. citizen or resident. Also, make sure that you have a foreign filing license granted from the USPTO before you do any of foreign filings. And then plan for formal drawings. So often your original U.S. application may be filed with informal drawings, so make sure you've got that in the plan. And then also, don't forget about the fact that your U.S. application may have been filed with a non-publication request. So as part of your foreign filing process, somewhere in your process you should have a check to see if the original application was filed with a non-publication request. And if it was, and then you subsequently foreign file, you need to file a request to rescind that within 45 days of the foreign filing. So that should also be somewhere in your process. Next, I'm going to have Chris walk through an example checklist for filing a foreign application at the 12-month date, or based on the 12-month Paris Convention filing deadline after you've had a U.S. application filed as the priority document. So this isn't a PCT application. This would be a direct filing or a regional filing based on the 12-month Paris Convention timeline. So Chris, can you walk us through that process?
Yeah. So what I do when I get instructions to enter other jurisdictions, I open the matter in our database, which we use Foundation IP. If we're filing off of a provisional or claiming priority, I open the matter off of that case. So all the priority information rolls into our database, and that just helps launches other docket dates. And then we do also verify if the inventors are non-U.S. citizens or residents. And that's, again, if we're claiming priority to an application. And then that information is on the filing receipts, too. So if there's a provisional or U.S. application or another, for the USPTO, on their filing receipts, they list on there if someone is given foreign filing license. Mm-hmm. So we just review the filing receipt. We double check the assignments if we have assignments. If we don't, we try to obtain them before filing. Most of the time, if we don't have them when we're filing the application, we have the application filed in the inventor's names, just because we'll have to show proof of the assignment if we don't have it right away, and then that could cause, a mess if you don't have it right away. We review the formal drawings, basically the application that we're going to send to the associate. We want to review the application to make sure everything's in order as far as the number of drawings, if it matches the number of drawings we have, if the claims are consistent, numbered correctly, if there's an abstract, all that stuff.
So before we go on to the next slide, which has more steps in your checklist, I just want to comment on item number 1. You indicated, because you use Foundation IP, that you're opening the record as a direct filing and the priority information will pull over. Mm-hmm. I'm assuming that we have a number of listeners who have other docketing systems. I think what you have highlighted here, though, is something that some other docketing systems also do. Mm-hmm. So when you're opening that initial record, if you're tying it to the parent record, a lot of times then you can pull in a lot of the information from the parent record, which saves time and also reduces potential errors too, when you're pulling in that information. So I just wanted to generalize that step a little bit because I think it applies fairly universally. Are you ready to go on to the next one?
Yep.
Okay.
So here again, I touched on this just a little bit before, but like I said, we review the priority application. A lot of the times when you enter foreign off of a provisional, you tend to use the same application. So it's a good idea to double check with the attorney to see if they want to add any more to the specification and if the claims are right. Like a big thing for Europe is, you're going to pay excess claim fees if you go over 15. So it's our practice to not do that. And then, so sometimes we'll have to get a different set of claims from the attorney when filing. We review to see if there's any tables or formulas that are included and if they're printed correctly. And the drawings that match. There's different things to think about with other jurisdictions. Some, different laws with the drawings, like China, for example, doesn't allow shading on their drawings. So you need to make sure that all of that is acceptable. A lot of the times the associates will let you know if something is not correct or they need something to be edited or amended on it.
Are there some countries that don't allow text on the drawings too?
Yes.
Yeah.
and I can't think of which countries that is off the top of my head.
No, that's okay. I
Yeah,
can't either, but
there's a few.
The point is that depending on what countries you're going to be filing in, you may need a different set of drawings, even if you already have formal drawings from your priority application. Those may need to be updated
Exactly.
for country-specific requirements. So I think that's a great point that you have that on the checklist.
Mm-hmm.
Okay.
Next, then we go to the application. If you're using an application from a priority, a lot of the times you have client reference numbers or your own reference numbers on those. You want to make sure, we make sure that we update it to the current one if we add it at all. We usually include instructions when we file about requesting an examination and who is responsible for the annuities, just for later down the road. Well, either when they enter, they can file the request for examination at the same time, and then they already know who will be responsible for annuities, which I think is helpful. And then we create the instruction letter, which will list all of the details of the application that we're requesting they file. So we double check the applicant is correct, the inventor information. It usually will list their name, address, citizenship. Certain countries need to have, the citizenship information. So the client reference number, if it's known, we provide the assignment document, the applicant corporation state correct. You just have to double check the assignment, how the assignment is worded.
Okay. So the order letter is then sent to the agent, right? Or maybe that's the next slide. Let me see. It's coming up. Okay, I'll let you go.
So we, for the direct filings, we do provide the filing receipt, which, like we said, will show if a certified copy can be obtained by that foreign associate from the USPTO. So we don't have to make that extra step to order it. The associate can do that on their own. We double check again, just reviewing the application, the sequence listing, biological deposits, and then we send the associate the letter with the filing receipt. We provide a Word and PDF copy of the application. It's nice to have, the Word copy so they can make edits if necessary. The drawings, all the priority assignments, if any, and any other documents that we know are going to be needed. And then we let the client know that we sent it. And then in our database, once we send it, we add a template code that will launch a deadline that says associate acknowledge receipt of instructions to file application. And so if we don't get that acknowledgement from the associate, I believe it's within 5 days, then we, make sure to follow up with them if we have time. Otherwise, what we do as just a best practice is if we don't get confirmation from the associate that even the application was filed the day prior to the deadline, we will send them an email asking them, please confirm that the application was filed today or will be by the deadline.
Okay.
Just so we have record of that too.
Okay. So this is basically the process that you follow, right?
Yeah.
Is this process any different if you're doing a national stage filing off of a PCT application versus just a 12-month Paris Convention filing?
It's not that much different. The only difference is that we provide a lot of the PCT documentation to the associates, like if there's an IB 306 or the priority documents, the ISR, that kind of thing, we provide to them, the request form.
Okay.
So it's basically the same, just different documentation and different wording in the order letter that, states what it's claiming priority to, because even when you file a PCT application or you're filing off of a PCT application, you still list say it was a provisional as the priority. And then you mention that this application is being filed off of the PCT application. So.
Okay. So very similar checklist then.
Yeah.
Thinking about this from, again, a process standpoint, some of the things that stand out to me that seem to be very important are that planning ahead and having an actual docketed date somewhere well before the foreign filing deadline to review and make sure everything's in order.
Mm-hmm.
And then also that last piece that you mentioned, docket a follow-up to confirm that the application has actually been received and filed, right?
Yes.
Those two things probably save a lot of trouble
Yes.
down the road, in addition to doing all the other things on this checklist well. Okay, so now you talked about the docketing that foreign agent confirms filing, and just when they do confirm the filing, what are you doing at that point? What are you updating? What are you tracking? And
I add we enter the date that they acknowledged receipt of our instructions.
okay,
And then in our system, that will launch a foreign agent confirms filing the application, the filing receipt, a request for examination if it wasn't filed at that point.
mm-hmm.
And then the next thing is and then we do have, so we do also have, let's say, for example, the application is due to be filed May 22nd.
Mm-hmm.
Well, when we open that matter
Mm-hmm.
off of the provisional, let's say, that deadline is docketed in the provisional application, not necessarily in like the Australia application that we're filing.
Right.
So then what happens is I don't clear that date
Mm-hmm.
out until I get acknowledgement that the application was actually filed.
Okay.
So then once that happens, I'll clear that date out, and then I know
Okay.
we're good. If we don't, like I said, for some reason get acknowledgement that the application was filed the day before, we'll contact the associate and ask them to confirm at least. They don't need to report all the details, just, yes, it was filed.
Okay, so you don't take that date off until you get the confirmation.
Yep.
And then you're also looking at that foreign agent confirmation to get the local filing date, the application number if they included it in their report, in their confirmation, or maybe that comes later in a later report out letter.
Mhm.
But if you get it at this point, you're going to put it in, right?
Exactly.
And any other deadlines that they may mention too.
Mm-hmm.
Okay, good. You commented on something that I'm not sure that everybody will pick up on, but you talked about updating the system that instructions were sent. One thing that I see that is a process difference from one organization to the next is how they docket the foreign filing deadline. And this is more of an operations webinar, but I just want to comment on this because some places, and I know this is how you guys do it, docket both a instructions to agent date as well as the foreign filing deadline, right?
Mm-hmm.
So when you send those instructions out, you close out the instructions sent, you close out the instructions due date,
Mm-hmm.
but not the foreign filing deadline.
Correct.
And that then launches the watch for foreign agent confirmation docket date as well. That foreign filing deadline is still in the system, is what you were saying, though.
Correct.
And that doesn't come off until you get the confirmation.
Exactly.
So there's a lot of things that are involved just around tracking the deadline itself in the docketing system. Okay. Those are all really great tips. Before we go into questions, Aletha, is there anything that you would like to add to what Chris just walked through?
Yeah, when you're doing something like this, it really takes trust on both parties and a great amount of communication regardless with your, the company side and the outside counsel side. I can tell you I can pick up the phone or drop an email to Chris any time of the day, and I get very good service. And with that aspect, it allows you to just be more aware of what's going on, and you just have to have a rapport with that outside counsel to build this type of relationship, and then it becomes a win-win for both sides.
Well, that's a great comment. And also, I think part of the reason why it probably works so well with both this firm and this company is that both have good processes in place. And certainly, I know from my practice, there were times when you had clients that didn't have processes in place, and just trying to chase them down and get instructions, that just made it even more complicated and sometimes pushed things down to the wire. So, this is an operations webinar series, and that was one of the reasons why I wanted you to present, Aletha, because you have such a good process there, and it's so streamlined and efficient. And that really, I think, supports that, in addition to the good teamwork that you talked about, make it very, very successful. So that's a great comment. I appreciate that. All right, just want to remind everybody that you can submit questions if you have any questions today on the using the control panel that's on the right-hand side of your screen. There's a box for questions, and I'll give everybody a minute to enter questions if you have questions. While you're doing that, I also want to remind people that if you have questions about Black Hills IP and our services or processes, you can contact our Vice President of Sales, Jim Brophy, and his contact information is on the screen. We do have one question, and I think this is directed to you, Chris. So the question is, let me get the question. The question is, when confirming receipt or filing of the application with the associate, do you resend the documents or just request confirmation? So I'm assuming you get down to the day before and you don't know that anything's been filed. Do you also resend the documents just to be safe? That's a great question.
That is a great question. And I know this has happened with some of my colleagues even, and this is why we're so careful with this. Normally, I just send the email. I forward the email that I sent them and say, please acknowledge receipt. If I don't hear from them by the end of the day prior, we will tend to send it to another associate just to make sure the bases are covered. And, and with that, you can tell them, you don't necessarily have to pay the filing fees. So we would tell them to maybe not file or pay for the filing fees just to ensure that the application gets filed. So we don't want anything to get missed. So
right,
that's how we handle that.
And when you forward the original email, because you are forwarding it, the attachments would be going along with it, right, to that original associate. Yeah. And then obviously you're sending the whole package to the new associate if you get down to the wire.
Exactly.
For your safety filing, precautionary filing, whatever you want to call it.
Yes.
Okay. That's all we have for questions today, and we're actually getting close to the end of our time anyway. So just one final thing that I want to note for the audience, if you have questions about formalities, we did a 3-webinar series last summer in our Docketing Excellence webinar series, focused on the formality requirements in various countries. I think we picked roughly the top 15 or 20 countries that are the more common countries that people file in, and walked through country by country the various formality requirements and how to track and docket them in this webinar series. So if that's something you're interested in, you can go to the Black Hills IP website. That would be under the Our Educational Resources tab, and then there's a area for docketing content, and that would be one of the prior, there are actually 3 prior webinars specifically on formalities, and I think they were presented in the May to August timeframe last year. And then there's quite a number of other webinars. All of our previous webinars are recorded, and the slides and the audio recordings are all available on our website, as well as any upcoming webinars. Those are also listed on our website, and you can register for them there. So hopefully you'll be able to take advantage of that. Actually, I see one more question now we got a bunch of questions rolling in. Let me just do a couple more questions. So, Aletha, this one's for you. Do attorneys decide countries or someone else in the organization? So is that a legal and an attorney decision or a business decision, I would think is the point of the question.
Right, it's an attorney's decision.
Okay. And that's largely, and that's based, though, on a lot of business considerations, right? And you mentioned some of them earlier when you were talking about the where the product is likely to be sold or manufactured, potential licensing opportunities, whether or not you're likely to enforce in a particular country. So it's the attorney making the decision, but some of that is business-related factors that they're considering, right?
Yes, no, that's totally correct.
Okay. So the next question, let me just see. Can you kindly provide me with where I can get the checklists that are used? I work for a sole practitioner and would like to review them. Actually, what we did is I took the actual SLW checklist and distilled it down on the slides that Chris walked through. Those are the non-law firm specific procedures. Obviously, every law firm has some internal specific things that are just unique to the firm. But what we have in our slides, even though it wasn't really in a checklist format, it was more of a numbered list. Those 12 things are basically Chris's checklist that she uses for the filing. So you could take that and then add anything to it that would be specific to your particular firm or practitioner that you're working with. Okay, so those slides our slides from today will be posted online. Give us a couple of days to get them up, but we will have the slides as well as an audio recording of today's program available that you can go back and look at if you want as well. So thank you again. I really appreciate the time, Elisa and Chris, and the information that you shared. And I want to thank the audience for joining today, and hopefully you'll join us for more webinars in the future. Thank you, everyone.